minor issues. All right. No one else is on screen.
Oh, he played me. Oh, so he actually didn't have that. Yes, ma'am, that's his.
Yeah.
Yeah.
All right, if members of council are ready, it's after 6, we have a quorum. I'd like to go ahead and call to order a special called meeting at the Town of Sioux Falls Council on May 13, 2026, 6 p.m. And we'll begin with a moment of silence. Amen. Need to have a motion to approve our agenda as presented. Jimmy makes the motion, Scott seconds. All in favor? Greg? Unanimous? All right. Need to have a motion to approve the consent agenda. Jimmy makes the motion, Scott seconds. All in favor? Unanimous? Greg? All right, that's fine. I know you're trying to catch up. There's a lot there. Do we have an attorney's report? No attorney's report, no old business. First item of new business is, a resolution adopting a school zone camera revenue transition policy and appropriating funds. Basically, the laws about to change on how we can use the school zone camera money, public safety money. We've already got things allocated for the money we've already collected. I believe this resolution is just to help kind of cement that. And protect it from the new legislation coming in, since it was collected under old legislation, so. Warren, Linda. That's right. So that's pretty much it, unless y'all have some questions about it. If not, then I'll take a motion to adopt this resolution. Scott makes the motion. Craig seconds, all in favor, it's unanimous. All right, then I'm not sure about this other resolution. I think there was a personal injury case against the city. And this resolution is.
So. In a nutshell, Chang was a college student whose car wasn't drunk or anything, but unexpectedly left the lane of travel, hit a concrete planer within the city right of way, but outside the lanes of travel, flipped the car, killed him. Sovereign immunity for that normally capped at, 750,000 or whatever. Trial court ruled that sovereign immunity did not apply, and the jury awarded 35 million against the city of Milton, which appealed. Supreme Court reversed that, said that the waiver of sovereign immunity they were relying on, the trial court relied on, not actually a waiver of sovereign immunity. But then they said, we don't decide whether there's other waivers of sovereign immunity, so send it back down. This is the big municipal case that's going on right now. We didn't participate in the amicus briefing at the Supreme Court. The reason being, we didn't have a meeting to adopt a resolution like this. So there's a coalition essentially sponsored somehow, probably by the Georgia Municipal Association, that is asking cities for help and input and to join further amicus briefs, because when the Supreme Court abandoned it, it went before the appeals, so it just keeps on going. So that's in a nutshell what the resolution says. I will not be writing a brief from blank page to full brief. There's probably a brief writing committee or somebody would put one together, kind of circulate it to participate lawyers from the cities that have adopted a resolution like this. And, you know, assuming that it's not crazy, you know, we would add our name to it.
So, yeah, that.
Just be motion to approve that resolution.
So unless y'all have any other questions about it, then I'll take a motion to authorize to adopt this resolution. Scott makes the motion, Mike seconds, all in favor, unanimous. All right, for the main reason we had to call a special meeting, I need to entertain a motion to go into executive session for OCGA 50-14-2, commonly known as litigation, to consult with legal counsel pertaining to pending or potential litigation, settlement claims, administrative proceedings, and so forth. Also for OCGA 50-14-3, subsection B, subsection 1, commonly known as real estate and or litigation to authorize statement or settlement negotiations and acquisition of property. Also for the purpose of OCGA 50-14-3, subsection B, subsection 2, commonly referred to as personnel, to discuss or deliberate on the appointment, employment, compensation, hiring, disciplinary action or dismissal, or periodic evaluation of or rating of a public officer or employee. No evidence will be received and no argument will be heard on personnel matters during this executive session. Further, any vote on a matter covered by this paragraph shall be taken in public. Finally, on OCGA 50-14-3, subsection B, subsection 4, portions of a meeting during which a portion of a record made exempt from public inspection under the Open Records Act is to be considered by an agency, and there are no reasonable means by which the agency can consider the record without disclosing the exempt portions of the meeting were it not closed. So I need a motion to that effect. Scott makes the motion. Need a second. Mike seconds. All in favor? Unanimous. We are now going to move into executive session. And we will invite you to remain with us.
Are we gonna have open comments later?
No open comments on this meeting.